My name is Renata Voss. I'm 34 years old. And the Thanksgiving night my aunts divided my mother's property on a paper napkin while I packed up her bedroom was the night I understood that being the person who shows up, who stays, who does the quiet work without asking for credit, that person is also, in certain families, the person everyone assumes will simply absorb whatever is decided without them. My Aunt Sylvie said it while I was down the hall. I heard it through the doorway. Over the low sound of the television someone had left on in the living room and the scrape of chairs being pulled closer to the table. She said, "She won't fight it. She never does." And then the conversation continued, papers shuffling, someone uncapping a pen. I was holding one of my mother's sweaters. A gray cardigan she had worn every winter for as long as I could remember, the kind of garment that stops being clothing and becomes a fact about a person. I set it on the bed beside the box I was filling. I stood still for a moment. Then I went back to folding. What none of them knew, what none of them had thought to look for, was that my mother had spent the last 2 years of her life making sure that the property they were dividing at her dining room table was no longer hers to divide. She had transferred it into a revocable living trust 14 months before she died, with me named as the sole successor trustee. The document was signed, notarized, filed with the county recorder's office, and sitting in a manila accordion folder in the bottom drawer of her home office desk, labeled in her handwriting, "Renata, Trust Documents. Do not discard." I had driven past that desk 4 times already that evening. The napkin was still in my coat pocket when I walked out to my car at 11 that night. I did not say goodnight to anyone at the table. I got in my car, and I sat in the driveway for a moment with the engine off and the November dark pressing against the windows. Then I started the engine and drove the 20 minutes home. Before I explain what happened in the weeks that followed, I need to explain the architecture of my family because the architecture is the reason any of this was possible. My mother, Diane Voss, was the youngest of 3 sisters who had grown up on a piece of land outside a small Georgia city, not a farm in the working sense, but a property that had been in the family long enough to have become, in the way such things do, less a piece of real estate than a set of ongoing claims. 41 acres in total, 3 separate parcels. The main parcel with the house my grandmother had built in 1962, a second parcel of open land to the east that had been used intermittently for a small hay operation and then leased to a neighbor, and a third parcel, the smallest, that held an outbuilding my grandfather had converted to a workshop in the 1970s and which had been used for storage since his death. My grandmother had left everything to my mother, not to my aunts. My grandmother had her reasons, which she had not explained to anyone while she was alive and which could not be asked about afterward, and what her reasons produced was a situation that had been technically settled for 11 years but had never, in any practical sense, been resolved. My aunts, Sylvie and Carol, had accepted the will's outcome in the way people accept outcomes they intend to revisit. They were cordial at family events. They helped when help was asked for. But the property existed between them and my mother as a kind of ongoing question that everyone had agreed, by mutual silence, not to ask aloud. My mother had handled this the way she handled most things, by being precise. She kept the property taxes current on all 3 parcels. She maintained the lease on the east parcel, a rolling annual arrangement with a man named Herbert Gaines who had farmed the land for 9 years and paid $7,200 annually into an account my mother kept specifically for that purpose. She had the main house inspected every 3 years. She did not make improvements that couldn't be explained as maintenance, because she understood, without ever saying so directly, that the property's contested emotional history meant that any visible investment might be read as a provocation. I was her only child. I had grown up in that house until I was 12, when my mother moved us to the city for work, and I had come back to it every summer until I was old enough to choose my own summers. I knew which steps on the back porch had softwood. I knew that the east fence had a gap near the 3rd post where deer came through in the mornings. I knew where my grandmother had planted the camellia that still bloomed every January, stubbornly, regardless of what happened around it. My mother knew what the property meant to me. I think she understood it more clearly than I did for most of my adult life, in the way parents sometimes see the shape of things in their children before the children themselves can name it. What she did not tell me, until she needed to, was what she was planning. I should be accurate about what my relationship with my mother looked like in the years before she got sick, because accuracy matters here. I lived 40 minutes from her in a two-bedroom apartment in the city, where I worked as a licensed clinical social worker for a nonprofit serving adults with acquired brain injuries. It was not glamorous work and it was not particularly well compensated, but it was work I was good at and work that required a specific kind of attention, the ability to sit with a situation that is difficult and deteriorating and find, within it, the practical next step. I had been doing it for 9 years. I was good at it because I had grown up watching my mother do a version of it. Manage a complicated situation with precision and without drama, make the next necessary move, and not waste energy on the moves she couldn't make. I saw her most Sundays. I drove out on Sunday afternoons and we had dinner, and I helped with whatever needed help, a leaking gutter, a prescription that needed picking up, a document she wanted a second set of eyes on. It was not a sacrifice. It was a relationship, and I valued it in the ordinary way you value a relationship with someone who knows you. When she was diagnosed with an aggressive form of ovarian cancer in the spring of her 68th year, I adjusted my schedule to make room for what that meant. I did not move in with her, she did not want that, and I understood why, but I came more often. I sat with her oncologist, Dr. Patricia Weller at the Regional Cancer Center, and asked the questions my mother sometimes did not want to ask herself. I coordinated with her palliative care team, a physician named Dr. Samuel Okafor and a care navigator named Bridget Chu, who became over the following months something like a reliable fixed point in an increasingly unreliable situation. I learned to read her treatment summaries. I learned which side effects were expected and which needed a call. I kept a notebook. My aunts came to 2 of her appointments. Sylvie came to 1. Carol came to 1 different visit. They called on Sundays, more or less. They sent food twice, early in the diagnosis, and then less often, and then not at all. I understood the pattern. I had seen it before in my work, the way some people's capacity to be present for illness is genuinely limited not by indifference, but by a particular kind of dread that makes proximity feel unbearable. I did not have contempt for it, but I noted it. My mother noted it too, in her precise way. 14 months before she died, she asked me to drive her to a meeting with an attorney she had been seeing. The attorney's name was Helen Vargas, a trust and estate specialist at a small firm called Vargas and Coble about 20 minutes from the house. I had not known my mother was seeing an attorney. She had not mentioned it. When I asked how long she had been working with Helen, she said about 4 months. I drove her to the meeting. I sat in the waiting room while they met. When my mother came out, she was carrying a folder, the manila accordion folder that would later sit in the bottom drawer of her desk. She said, "It's done. Helen will explain if you ever need her to, but you shouldn't need her to." She handed me the folder in the car. I looked at the label she had written. I looked at the first page of the document inside. I said, "Mom," she said, "I know what I'm doing." I closed the folder. I drove us home. We had dinner and talked about something else. I put the folder in the bottom drawer of her desk, where she had asked me to put it, and I went back to my apartment and my Sunday afternoons and my notebooks, and I did not think about the folder until the night I heard my aunt's voice through the doorway, saying, "She won't fight it. She never does." The structure of what my mother had done was this. She had transferred all 3 parcels of the Voss property into a revocable living trust, the Diane Voss Family Trust, with herself as the initial trustee and me as the sole successor trustee, effective upon her death or incapacity. The trust document specified that the property was to be held, managed, and distributed at my discretion, with no conditions on timing and no required distribution to any other party. She had also included a letter of instruction, not legally binding but clearly dated and witnessed, explaining her reasoning, which I will summarize here without quoting directly, because her words were hers. She wrote that she had watched the property be a source of ongoing tension in her family for more than a decade, and that she had no interest in it becoming a source of ongoing tension for the next decade. She wrote that she trusted me to be fair, but that fairness did not mean equal, and that she wanted it clearly documented that she understood the difference. She wrote that she had consulted with Helen Vargas on 4 separate occasions over 4 months before executing the documents, and that her decisions were her own and had been made with full clarity of mind. Dr. Weller had provided a written attestation of cognitive capacity at the time of the trust execution, which Helen Vargas had in her file. The trust had been filed with the county recorder's office in accordance with Georgia recording requirements 11 months before my mother died. It was a public document. Anyone who had looked at the title record for any of the 3 parcels in the past 11 months would have found it. No one had looked. I arrived at Helen Vargas's office at 8:45 the morning after Thanksgiving. She had an 8:30 opening, and her assistant, a careful and organized woman named Priscilla, had scheduled me when I called from my car the night before. Helen was already at her desk when Priscilla showed me in. I put the accordion folder on the conference table. I put the napkin beside it. Helen looked at the napkin. She did not say anything about it. She opened the folder, checked the trust document against her own file copy, and confirmed that everything was in order. She asked me what had happened. I told her. I kept it factual: who was at the table, what I had heard, the general shape of what had been discussed. I said I did not have a complete picture of what my aunts were planning to do, but that based on what I had heard, they appeared to believe the property was available for division. Helen said it was not. I said I knew that. She asked what I wanted to do. I said I wanted to send a letter, a formal letter, on her firm's letterhead, to my aunts Sylvie and Carol, informing them of the trust's existence, its terms, and the legal position of the property. I said I wanted it to be factual and not accusatory, and I did not want it to make any threats, only to state the situation clearly and invite them to contact Helen's office with any questions. Helen said she could have a draft to me by the following Monday. I said that was fine. I thanked her, and I drove to the house, which was still my mother's house in the practical sense. I had more clearing out to do, and I spent 4 hours finishing what I had started the night before. I finished the bedroom. I sorted the kitchen. I found, in the bottom of a cabinet, a set of ceramic mugs my grandmother had bought at a roadside stand in 1971 and which my mother had kept for 50 years without using. I wrapped them in newspaper and put them in a box I labeled for myself. I did not call my aunts. I went home. The letter went out on the following Tuesday. Helen had drafted it over the weekend. It was 2 pages. It identified the Diane Voss Family Trust, stated its execution date, provided the recording reference number from the county recorder's office, named me as successor trustee, and noted that as such I was the sole authorized party with respect to any decisions regarding the 3 parcels comprising the Voss property. It stated that no transfer, division, sale, encumbrance, or agreement regarding the property could proceed without my authorization in my capacity as trustee. It invited Sylvie and Carol to contact Helen Vargas's office with any questions about the trust terms or their legal effect. Helen sent it certified mail, return receipt requested, to both addresses. Sylvie signed for hers on Thursday morning. Carol's was signed for on Friday afternoon. My phone rang for the first time at 11:47 Thursday morning. I was with a client. I let it go to voicemail. It rang again at 12:20 and at 1:15 and at 2:50. All Sylvie. Carol called twice that afternoon, once from her own number and once from a number I didn't have saved. I identified it as her husband Warren's cell when he left a voicemail that evening in a measured tone that was making an obvious effort to be measured. I listened to all of the voicemails that evening. I took notes on what each one said. Sylvie's first voicemail said there must be a mistake. Her second said she needed to talk to me before this went any further. Her third said that my mother had not been in her right mind in the last year of her life, which was demonstrably false, but I noted it as a position she was willing to take on record. Carol's voicemail from her own number asked me to call her back when I had a chance. Warren's voicemail said he thought we could work this out as a family and that he'd like to get everyone in a room together. I called Helen the next morning and relayed what I had heard. She advised me not to respond to any of the calls directly and to route any family communication through her office for the time being. She said she would prepare a follow-up letter addressing the competency question, referencing Dr. Weller's attestation, and making clear that any formal challenge would need to proceed through the courts. I said to prepare it. She sent it the following week. What happened in the month after the second letter arrived was a sequence of events that I observed from a particular distance. Helen handled the direct communications. I received summaries. What the summaries showed was this. Sylvie consulted an attorney of her own, a man named Douglas Frame at a firm in the city. Douglas Frame reviewed the trust document and the recording and Helen's letters, and he provided his client with an assessment that she apparently found unwelcome because Sylvie called me 3 more times in the week after she received it, in a tone that had shifted from the careful steadiness of the first calls to something more pressured and uneven. Carol's trajectory was different. She called Helen's office directly, which Helen had invited her to do, and she had a conversation with Helen that I was not party to but which Helen summarized for me. Carol had asked what the trust actually required of me in terms of distribution. Helen had explained that the trust gave me full discretion. Carol had asked whether full discretion meant I could distribute shares to her, and Sylvie if I chose to. Helen had said yes. Carol had thanked her and ended the call. Carol did not call me again after that conversation. She sent me a text message on a Thursday evening, 10 days before Christmas. It said, "I know this has been a hard few months. I hope you're doing okay." And then, after a pause indicated by a second message sent 4 minutes later, "I think Mom knew what she was doing." I read that message twice. Then I set my phone down and finished the dinner I was making. I want to be precise about what happened next because precision is what this whole story has been about. Helen convened a meeting in her conference room in the second week of January, 3 months after Thanksgiving. Sylvie came with Douglas Frame. Carol came alone. I sat across from Sylvie with Helen beside me, and I listened to Douglas Frame present Sylvie's position, which had evolved considerably since the first voicemails. The competency challenge was not pursued. Douglas Frame had clearly advised against it. What Sylvie was proposing instead was a negotiated resolution. She would acknowledge the trust's validity in exchange for a defined distribution from the trust assets. I let Douglas Frame finish. I let the room settle. Then I said I had thought carefully about what a fair outcome looked like, and I wanted to share what I had decided. I said I intended to hold all 3 parcels for a minimum of 2 years. Not sell, not subdivide, not transfer. I intended to maintain the lease with Herbert Gaines on the east parcel, continue paying the property taxes from the trust account, and complete a proper structural assessment of the main house, which had not been done since my mother's last inspection 3 years prior. I said I was doing this because my mother had trusted me with discretion, and discretion meant taking time to make a considered decision rather than a reactive one. I said I was also willing to offer Sylvie and Carol each a one-time distribution from the trust's liquid assets, not from the property itself, and not a share of any future sale, but a payment that I considered reasonable given the family history of the land and my grandmother's original decision to leave everything to my mother. Sylvie asked what the amount would be. I said $18,500 each. Douglas Frame said that was considerably below what his client had expected. I said I understood that. I said my mother had not been required to give them anything, and the trust did not require me to give them anything, and the $18,500 was what I was choosing to offer because I thought it was fair, and it was not going to change. The room was quiet. Sylvie looked at Douglas Frame. He gave her a small, precise nod that meant what it meant. She said she would accept it. Carol, across the table, said yes before I finished asking. Helen drew up the distribution agreement the following week. Both of my aunts signed it. The $37,000 total left the trust account in 2 transfers on a Thursday in late January. I drove out to the property that weekend, not to do anything in particular. I parked in the driveway of the main house and walked the perimeter of the east parcel in the January cold, through the dried grass, along the fence line where the gap was still there near the 3rd post. The camellia at the corner of the main house had buds on it already, tight and red against the gray morning. I stood there for a while. Then I got back in the car and drove home. It is April now as I tell you this. The structural assessment on the main house came back with 2 items, a section of subflooring in the back bedroom that needs replacement, and a chimney liner that is past its service life. I have contractors scheduled for both. Herbert Gaines has renewed his lease for another year. The property taxes on all 3 parcels are current. I have not decided what I will ultimately do with the land. I think about it in a way that is not urgent, the way you think about something when you have time, and the time has been given to you deliberately. My relationship with Carol is, cautiously, something I am tending. She came to the property with me in February, The first time she had been there since my mother's death, and we walked the same perimeter I had walked in January, and she pointed out where she and my mother and Sylvie used to climb the fence as children before the pasture was leased. I had not known that. I filed it away. Sylvie and I are not in contact. There is a thing I have come to understand about my mother's decision that I did not fully understand when she first handed me that folder. I understood it practically. I knew what a trust was. I knew what successor trustee meant. But I did not understand it the way I understand it now. She did not give me the property because I had earned it. She did not give it to me because I had sacrificed something. She gave it to me because she had watched over many years how I handled the things that were placed in my care. The clients I sat with, the notebooks I kept, the Sundays I drove out, the appointments I attended without being asked twice. She had watched what I did when things were hard and no one was watching, and she had made a decision based on what she saw. What I did with what she gave me was not what anyone at that Thanksgiving table expected. It was not dramatic. It was not punishing. It was the same thing it had always been. The next careful step, taken with as much precision as I could bring to it, towards something that might last. The people who wrote me off that evening were right about one thing: I don't fight. What they didn't account for was that I didn't need to. There's something I keep thinking about from that night. The specific moment when I heard my aunt's voice through the doorway while I was still holding my mother's cardigan and made the decision to say nothing and keep folding. I've talked to a lot of people about moments like that, moments where you know something they don't, and you make the choice to stay quiet and let what's already in place do its work. I'm curious if you've ever been in a room where someone underestimated you in a way that ultimately worked in your favor, not because you planned it, but because you'd already done the work without anyone watching. I'd like to know what that looked like. Leave it in the comments. Subscribe if this one landed somewhere real for you. New stories every week. This is an original fictional story created for entertainment and educational purposes only. All names, characters, events, and details are invented and do not represent real individuals or actual events.